Good morning and good afternoon, everyone. Thank you for joining us for today's webinar on EDI, the basics. This is the first webinar in Fasken's four-part EDI series running this month. My name is Judith Parisien. I'm a partner in Fasken's Ottawa office, and I'm pleased to introduce to you Florence Gauthier, who is an associate in our Montreal office. We both provide management side labor, employment, and human rights advice to our clients in areas such as employment standards, wrongful dismissal, employment contracts, labor arbitrations, negotiations, collective bargaining, conflict resolution. We'd like to begin by acknowledging that First Nations and Inuit have been present in Canada for thousands of years. These Indigenous peoples have a profound and ongoing attachment to this territory. At Fasken, we recognize that we have a role to play in the ongoing process of reconciliation between Indigenous and non-Indigenous communities here and elsewhere in Canada. We have embarked on the reconciliation journey by adopting a plan with the overall purpose of contributing meaningfully to reconciliation. Now I'd like to draw your attention to the information slide that is on your screen. With respect to the survey piece in particular, we truly value your feedback on our sessions, and I encourage you to fill in the survey before you log out of the webinar today. So on to our presentation. We're very pleased to see that there are so many of you joining today to learn more about how to navigate EDI journey and EDI principles within your organizations. As you know, there are increasingly important dialogues around EDI initiatives, and these initiatives really require careful planning, continuous reflection, and strategic advice. Florence and I will be guiding you through the basics of EDI as a first step in this journey. Our agenda really sets out the topics that we're going to be discussing with you today. We're going to start with the economics of EDI. This is where we share why EDI is the right thing to do, but also makes good economic sense. Then we're going to discuss some key EDI terminology. We did this in another session, and it was really well received by participants who, like us, are really trying to stay up to date with the ever-changing terminology in this space. We're going to review some common EDI issues. We're going to discuss the importance of following a trauma-informed approach. And finally, we are going to present a few notable cases and then answer some questions, time permitting. So as I mentioned, this is the first webinar of a four-part series that's running through the month of October. So you're not getting all of the answers today, and we really hope that you're going to continue to join our other speakers as we continue to discuss various EDI topics. Today, our objective is really to provide you with a key EDI competency and knowledge, hopefully get you better equipped to help your organization ensure legal compliance, mitigate potential risks, but also drive positive change and foster a truly diverse and inclusive workplace. So if we move on to the economics of EDI, from our point of view, EDI initiatives are not only the right thing to do, but they will also help your organization be in a better position to respond to challenges, to win top talent, and to meet the different needs of customer bases. Research has shown that diverse and inclusive workplaces earn higher revenues. They drive more innovation. They have better employee recruitment and retention results. We're seeing that statistics are showing, of course, that Canada's population is changing, and younger workers consider EDI at work to be of central importance. We know that the pandemic has changed our world in so many ways. And if you look at the first statistic here to the left of your screen, 86 people want to see a more equitable world after the pandemic. Also, 40% of employees said they would likely quit their jobs if their company did not prioritize addressing social or racial injustice. And 80% of US employees believe it is the responsibility of company leaders to take action in addressing racial justice and equity issues. Next slide, please. Indeed, if you fail to address and embrace EDI initiatives, it can cost businesses dearly. This can be in the form of higher turnover, decreased engagement and productivity, and as we'll see in the case law portion of our presentation, also as potential litigation. So let's look at a few of these other statistics that we have here. Gender diverse executive teams are 39% more likely to outperform financially. Ethnically diverse companies are 39% more likely to outperform. Inclusive companies are 1.7 times more likely to be innovation leaders in their market. And I'm going to move down to the bottom here. More than 3 out of 4 job seekers and employees report that a diverse workforce is an important factor when evaluating companies and job offers. So these are all reasons why we believe you should be EDI champions and supporters within your organizations. But promoting EDI initiatives also stems not just from performance and recruitment and innovation, but also from legal requirements. So if we move on to the next slide, you will see that employers have an obligation to provide employees with a workplace free from harassment and discrimination based on protected grounds. This is true in every Canadian jurisdiction. The protected grounds are listed in human rights legislation in each province and federally. They're generally similar across the board, but they continue to evolve over time. So, for example, in Ontario, the Human Rights Code was amended in 2012 to add gender diversity and gender expression. In the federal jurisdiction, it was the Canadian Human Rights Act that was amended in 2017 to protect those 2 grounds. And then a year prior in Quebec in 2016, gender identity and gender expression were also added to the Quebec Charter of Human Rights and Freedoms. So when it comes to harassment, that is also often defined in legislation. And here, if you look at the slide, you'll see an example of how that is defined in the Human Rights Code. And harassment means engaging in a course of vexatious comment or conduct that is known or ought reasonably to be known to be unwelcome. As an employer, you're required to investigate as part of your general duty to ensure that workers are not exposed to harassment or discrimination in their workplace. But if we move on to the next slide, you'll see that in addition to human rights legislation, in terms of legal compliance, you also need to consider the various provincial and federal occupational health and safety regimes. And under that regime, employers have to take all reasonable precautions to protect the health and safety of their employees. They have to have policies. They have to train their employees on those policies and those programs. And they have to investigate complaints. And we also added here incidents. And this is because depending on your jurisdiction, if, for example, you're in Ontario, you also have to investigate incidents. And by that, I mean, take the example where an employee comes to human resources and says that they have incurred or either witnessed or experienced some harassment in the workplace. If that person doesn't wish to go ahead with a formal complaint in Ontario, you would have knowledge of a harassment incident and you would still be obligated to proceed with an investigation. So then you also have, after that investigation, have to report on your findings. In terms of what the employer can be responsible for, you want to think a little bit outside the box. These incidents can occur off of the employer's premises. They can occur outside of working hours, and they can occur between an employee and a third party. Think again about the pandemic that has really thrust everyone in a more virtual world as we are today. And so incidents can, of course, also occur in a virtual working environment. Moving on to the next slide, we're going to look at what happens when there is no legal compliance and how that can result in legal liability. So That legal liability can can take different forms: human rights damages, special damages, aggravated damages, and also constructive dismissal damages. And we've really seen in the past year throughout Canada an increasing willingness to order awards against employers and organizations for failing to appropriately deal with EDI at work. In the case of constructive dismissal, the adjudicators have really recognized that the law of constructive dismissal applies to situations where an employee resigns because they are the subject of a toxic environment. Of course, the type of remedy and the amount of damages is going to depend on a series of factors. That's going to include the nature of the behavior, the frequency of the behavior, the circumstances of the victim or the recipient of the discrimination, the vulnerability of that person, and the psychological impact of the behavior on that person. When it comes to reputational harm, of course, that's a little bit harder to quantify, but it can still present a pretty serious risk to employers, and perhaps even more so now with the advent of cancel cultures, and we're seeing some coordinated efforts of some social movements that are willing to target some businesses and organizations. So now I'm going to move it over to Florence, who is going to help us learn the continually evolving terminology in this space.
Thanks, Judith. So as Judith mentioned at the beginning of the conversation, we wanted to take the time today to discuss with you different terms, definitions that are used in the context of EDI subjects. We know it's evolving quickly. We know you may not, as of today, know every term or understand every terms, but that is completely normal. We are all still learning together, and we are here today to try and simplify maybe some of these terms with you. And just the fact that you're here today, this morning with us, willing to learn and willing to get more knowledge on the subject is a very great way to start. So if we move on to the next slide, first term we wanted to discuss with you is intersectionality, which is the way in which different types of discrimination are connected to or affect each other. There's a very well-known lawyer and activist in the US that tried to explain that concept more visually by saying that we could see it as if racism road crossed with the streets of colonialism and patriarchy, and crashes occurred at the intersections. So we see how different concepts, different types of discrimination can be connected together and affect together with that imagery. Next, we have racism and sexism, which are maybe the most well-known terms. For racism, we included I'd say, basic and very wide used definition, which is the belief of some races that some races are better than others, or the unfair treatment of someone because of his or her race. But know that it is an evolving concept, and that the definition is also evolving. Some are longer than others. Some include systemic racism. We're going to discuss systemic discrimination later on in the presentation, so you're going to get a glimpse of that also. Next is sexism, which is the belief that members of one sex are less intelligent, able, skillful, etc., than the members of the other sex, which is something that we can see often in the workplace. And we're also going to discuss that in more depth later on in the presentation. Next slide. So if we move on now to parity, which is the state of being equal, especially in relation to pay and position, this is also linked to employment and workplace issues. We can think about parity issues with pay gaps, issues getting promotions. So that is something that you are probably aware of already within your organization. Same goes for gender gap, which is a difference between the way men and women are treated in society, or between what men and women do and achieve. So that is also something we're going to address a little bit in more details later on. Next, we have 2S LGBTQI+, which is the official acronym that was adopted by the Government of Canada to refer to the Canadian community. So 2S stands for Two Spirits. L stands for lesbian, G for gay, B for bisexual, T for transgender, Q for queer, I for intersex, which considers sex characteristic beyond sexual orientation, gender identity, and gender expression. And the plus is added in order to be the most inclusive possible and to include people who identified as part of sexual and gender diverse communities or who would use additional terminologies that are not already integrated in the current acronym. Next slide. We also have SOGI, which is the acronym for sexual orientation, gender identity, and expression. And we will go over these specific terms in the next few slides. So don't worry, we're going to address that also. But simply SOGI is an acronym that we see more and more here and there, really to easily include these concepts within conversation. So Two-Spirit, I mentioned it with the 2S LGBTQI+ definition. It's one of the components that includes a spiritual identity, which is really interesting. It's an English term that is used to broadly capture concepts traditional to many Indigenous cultures. It's a culturally specific identity that is used by Indigenous people to indicate a person whose gender identity, spiritual identity, and or sexual orientation comprises both male and female spirits. Cisgender is a person who identifies with the gender they were assigned at birth. Then we have gender fluid, which is a person whose gender identity will vary over time and may include male, female, and non-binary gender identities. And you will see in the next few terms that we are going to discuss, we're going to see a lot of fluidity, spectrum. As we said earlier, it's an evolving subject, and there's place to change and in evolution in the next few years. Next slide, we have intersex, which we also mentioned earlier. Intersex has a more medical and biological connotation. It's a term that captures various types of biological sex differentiations. Intersex people will have variations in their sex characteristics, such as sex chromosomes, internal reproductive organs, genitalia, and or secondary sex characteristics that will fall outside of what is typically categorized as male or female. Non-binary is also referred to as genderqueer, is a person whose gender identity does not align with a binary understanding of gender, such as men or women. It's a gender identity which may include men and women, androgynous, fluid, multiple, no gender, or a different gender outside of the woman-man spectrum. Non-binary is the term that I'd say is most currently used at the moment, but we're seeing an emergence of the term gender diverse also, which is gaining popularity within the community. So you may start hearing that, which is also a term that is inclusive of for non-male and non-female identities, similar to non-binary and genderqueer. Next, we have gender dysphoria, which is a medical diagnosis that will often be required by medical or psychological professionals or even health insurance plans before they can prescribe hormonal therapy or even gender-affirming surgeries in the context of a transitioning process for a transgender person. It can be understood as a discomfort or even a distress that is experienced by such a person who feels that their sense of their gender identity differs from their body based on societal expectations. And gender dysphoria is the opposite of gender euphoria. Gender euphoria is the contrary, which is where gender aligns with a person's sense of self, causes a person to be happy, feel at ease, feel at peace. So often we're going to see the use of these terms for transgender people. They're going to feel gender dysphoria before transitioning, and then they're going to be able to name feeling gender euphoria once they've completed their transition process. Next slide. So now we have gender expression, gender identity. We've used both in the definitions of previous terms. So gender expression refers to the various ways a person can express their gender identity. So it can go with clothing, hair, makeup, accessories, and it may not align with societal expectations of gender. It's not a reliable indicator of a person's gender identity. Gender identity, on the other hand, is the internal and deeply felt sense of being a man or a woman, both or neither. A person's gender identity may or may not align with the gender typically associated with their sex at birth. And it can also evolve and change over the course of a lifetime and over time. Then we have transgender, and we also use trans, which is a person whose gender identity differs from what is typically associated with the sex they were assigned at birth. And quick note on different terms that are no longer used. With transgender, you might have heard in the past the use of transsexual. Such term has been rejected by the trans community because of its historic negative connotations and associations. Usually people relate to transgender and trans more now. So we would recommend not using transsexual unless somebody identifies as transsexual, since those terms have evolved over the past few years. Next slide. And now Judith mentioned cancel culture a bit before also. It's a term that was popularized by Twitter users as a public call for accountability, mainly in the form of boycotting of individuals, but also of entities and organizations that were allegedly engaging in behaviors or expressing opinions in conflict with or not supporting the evolving social landscapes. There's many examples that happened over the past few years. We can think about the Black Lives Matters movement, where racist companies or anti-Black companies were boycotted online on Twitter, Instagram, Facebook. Same goes for the Me Too movement, where there were a lot of denunciation and calls for cancel culture on social medias. So as an organization, as companies, you should be aware of such movements and be careful, because as Judith mentioned, it can have a reputational effect and harm over one's organization. So, and we're likely to see more and more cancel culture movements in the next few years with the presence of social media. So now I will let Judith take you through different common EDI issues.
Thank you, Florence. So if we move on to the next slide, in order to properly engage in your journey to support EDI principles and initiatives in your organizations, you need to take a step back and consider some of these important EDI concepts, such as bias, stereotypes, and microaggressions. And as you may know, our biases are really our opinions that we form based on our personal experiences. They're really based on what we hear from others, whether they're our friends, our family, what we read in social media, what we see in the news. It comes from institutional influences. It comes from our culture, and it comes from our upbringing. There are both explicit and implicit biases, but an important bias that we often hear about in the context of EDI initiatives is really the concept of an unconscious bias. So I'd like to move on to the next slide to talk about unconscious bias a little bit. And this type of bias can be difficult to address because it's not deliberate. It really is unintentional. often we don't even realize that we're making these unfair assumptions or stereotypes about others. And it's really important that we stop and remind ourselves to consider whether our conduct or judgment of what we're perceiving in our environment is being affected by our own unconscious bias. So let's take an example in the context of affinity biases, which is one of the types of bias that we include here. The affinity or even performance bias is really a situation where we're going to be more likely to believe or to like or even to favorably evaluate somebody who we have an affinity with. So take the simple example of an interview. We're conducting an interview and we realize that we have so much in common with the person across the table from us. In that context, if we're not careful in our approach and considering our own unconscious bias, we may be more likely to hire that person or to give them a higher ranking in the criteria of the interview process. There's also confirmation bias that we've listed here. And this is where our interpretation of the information we receive is influenced by what we already think happened. And confirmation bias also affects the way that we remember information we actually do receive. And in that context, I'll call it like selective memory, where we really remember what we thought was important. So next slide. So a question for all of you joining us online today is, be honest with yourself. Do you have unconscious biases? And you don't have to answer because the answer is yes. The important thing is just to acknowledge it. We all have unconscious biases. And what we need to do is really stop, think about our own biases, and make sure that we avoid making decisions that are based on stereotypes and instead take decisions that are supported by the facts and factual observations. If we move on to the next slide, another EDI concept that comes up a lot, especially in the workplace, is the concept of microaggressions. These microaggressions are really they come from our biases and they come from our stereotypes, and they can make the workplace feel uncomfortable and frankly, often unsafe and toxic. A microaggression is a behavior or a communication. It can be spoken, it can be unspoken, that feeds into stereotypes. They're slights, they're indignities, they're put downs, experienced in day-to-day interactions by the recipients of these microaggressions. And they're really viewed as racism, sexism, ageism, and ableism. We'll move on to the next slide. What's key is that people are often unaware that they've engaged in an offensive or demeaning way. It's often communicated through language. So we really need to pay attention to how we talk and what we say in the workplace, because the result is that even though the recipient feels insulted, they often don't know how to respond. So let's look at a few examples if we move on to the next slide. And we've listed a whole bunch of them. One of them can be, oh, your voice doesn't match you, or you don't sound like the way I thought you would. Microaggressions can even include commenting on jewelry choices or on clothing choice. It can be something like saying, oh, you're transgender, you don't look like it. And on the topic of transgender, this has come up in the case law, and we'll talk a little bit about it further in the presentation. But, a microaggression for a transgender person can be essentially asking them to give you like a 101 transgender lesson and answering a whole bunch of questions. Of course, we're not trying to prevent, kind of good faith and well-intentioned questions. What you want to avoid is really putting the onus or the burden on the transgender individual to essentially educate you on everything that's transgender, for example. The message that we're trying to give is that it's a shared responsibility, especially, for example, if you're part of an organization's human resources. It's okay to ask questions, but it's also important for individuals to show real engagement, to research some issues on their own time, on their end, and to take the initiative to learn. In that area, really organizations can help employers by providing, organizations can help their employees learn by providing them with training and education. And hopefully by doing that, we are going to minimize the amounts of microaggressions in the workplace and the discrimination that is faced by certain groups. So consider training on unconscious bias, consider training on microaggressions, what they are, what they're not, and how to create safe places. But before we move on, I wanted to raise this website that I came across in the context of another presentation, and the participants in that session really enjoyed it. So I'm going to refer to it again. It's a Toronto firm called Zulu Alpha Kilo. They have created a website called the Micropedia of Microaggressions. On that website, they have a whole bunch of different tabs. They have tabs for race, gender, disability, religion. And then if you click on each individual tab, you're going to get some examples of the microaggressions that certain marginalized groups can face. And so over to you if you want to go ahead and take a look. Again, I'll give the name, the Micropedia of Microaggressions. So I'm going to turn it over to Florence now, who's going to discuss systemic discrimination and racial profiling.
Thanks, Judith. So systemic discrimination is a heavy expression that is often used, but maybe not well understood. And it can seem like an abstract concept to really grasp what it means. Some authors try to explain it as it's like pollution that's always in the air. You can't really see it, you can't really feel it, but it's always there, and it has an impact on everybody, and it can even be deadly. So I thought that was a nice imaging to start this section with. Systemic discrimination is essentially the cumulative effects of exclusionary practices that result from biased attitudes and stereotypes, which are very often unconscious, as Judith explained previously, combined with policies and practices usually adopted without considering specific characteristics. Sorry, my French is wanting to take over today. Characteristics of groups protected against discrimination. So we can see different examples of systemic discrimination in different sectors of our society. It can be within our education system, our health system, or even employment or the workplace. Examples of this can be for within the pay gap that is still there in 2024 between men and women in the workplace. We can also think about the underrepresentation of people of color in leadership positions, the underrepresentation of Indigenous people in the workplace, and also the fact that people with handicaps are still less likely to get a job or a position, even in 2024. Systemic discrimination often has a long-lasting impact on identifiable groups such as gender, age, skin color, disability, so specific characteristics that are going to impact these people from such groups. It can manifest as disproportionately unfavorable hiring advancement opportunities, especially for women, Indigenous people, ethnic minorities, visible minorities, and people with disabilities. And it's something that is, as I mentioned, not necessarily voluntary or conscious, but it's integrated in our different structures, systems, processes, which may seem to be neutral or equal for everybody, but in the end, they are not, because of specific characteristics of some of the groups that are often discriminated against. And one example I wanted to share on that is a case that happened a few years back in the US, where some Uber drivers were complaining that the system of the app and the rating system of the app was unfavorable and discriminatory against people of color, so drivers of color. And there was a study that was conducted which concluded that, in fact, even if the rating system was on its face neutral and it was seemingly impartial, it truly wasn't, because of the use of some users that impacted negatively, specifically people of color. So, for example, some users that had biases or that were racist would cancel routes with driver of color, or would give them bad ratings, which would affect their overall ratings, overall performance over the app. And that had an effect on the use by other users that did not necessarily have these biases, or did not necessarily have this racist attitude towards them, but still the general negative rating that they got on the app because of those few users affected them greatly in the end, reduced their ratings significantly, and even led to some of them being kicked off of the app, literally. So that's something that I found interesting to kind of explain how a system that can seem to be neutral from the start is not necessarily equal for everybody. That brings me to the next slide on how to address and remedy systemic discrimination. As I mentioned, it's a problem that is persistent and long-lasting and has been in our structures, programs, systems for a long time. So it will often require systemic measures in order to get an effective redress that will be proportionate to the prejudice that is caused, especially considering the persistent and insidious effects that such discrimination has on those specific groups of people. In the context of employment, one of the examples that we often see to try to remedy to these issues is the implementation of equality access programs, which aim to put in place systemic remedies to correct the situation for groups that are victims of discrimination. But we could also see similar programs be implemented in other public services, such as education, healthcare. In the context of employment, what we usually see is action in reviewing hiring practices, promotion opportunities and practices, pay structure, to see and try and identify and then correct different artificial barriers that prevent or limit people from these groups to get equal treatment or equal opportunity within the workplace. So next slide. Now on racial profiling. So we talked about racial discrimination and also systemic racism a bit before. Racial profiling is essentially the differential treatment or scrutiny because of negative stereotypes related to race. We can see it in the context of employment. For example, an employee that would be overly scrutinized because the manager or the employer thinks they're less skillful or less competent to do the job because of their race or skin color. We could also see it where studies show that candidates or employees with racial names or non-white names are less likely to get a callback or get hired. So those are examples of racial profiling which can happen within the workplace. As employers, as organization, you should be aware that such profiling exists, that it's a current issue, even if it's not specifically recognized by human rights legislation in Canada as of now, but it really often manifests and constitutes discrimination or could even constitute harassment also. So as employers, you should be able to be aware that such problems exist, be able to identify them and to act on them once you are made aware of such an issue. It can occur through different ways. It can be statements, it can be signs, symbols, or different employment practices even. So make sure that you are sensible to that issue, because otherwise, as for other potential EDI issues that we mentioned, there's obviously a potential liability regarding discrimination or harassment complaints. Now I'm going to let Judith get you through the trauma-informed approach.
Thank you, Florence. So if we move on to the next slide, as we've been discussing, I mean, these sessions, this is why we have a 4-part series, and there's lots of issues to address, but we're trying to give you the basics here today. And one of these EDI concepts is really about trauma. So we've given you a definition here. A traumatic event involves a single experience or enduring repeated or multiple experiences that completely overwhelm the individual's ability to cope or integrate the ideas and emotions involved in that experience. So moving on to the next slide, what we want to discuss with you today is really this idea of adopting a trauma-informed approach in the workplace. And that, in order to do that, you really have to have a baseline understanding of the impact of trauma and violence, and the impact it can have on those individuals that are seeking support. You want to recognize the signs and the symptoms of trauma, and you want to be able to respond by fully integrating knowledge about trauma into your policies, your procedures, your practices, and your different settings in the workplace. So if we go to the next slide, the goal of the trauma-informed approach is really about minimizing harm to the people that you serve. And that is whether or not you know their experiences of trauma. It's really not about treating the trauma, but it's about minimizing the potential for further harm. So a trauma-informed approach can be used in various settings. The goal is to create an emotionally and physically safe environments. It's to foster opportunities for choice, for collaboration, for connection. And what you have to appreciate is that people who have experienced trauma can be impacted in the way that they remember and they perceive events, but also in their ability to recount the details of those events. They can be emotional and they can react in ways that are not expected, for example, in the context of an investigation. So investigators out there, you should really be ready to deal with these types of situations. And some examples in terms of switching up your approach a little bit to your investigations can be simply by asking the person to start where they feel comfortable, as opposed to starting from the beginning. It can be about asking a little bit more open questions when it's possible. It's trying to be neutral by really focusing on helping or the person helping you understand what happened. It's empowering them by asking them if you've missed anything or if there's anything else that they'd like to add. And really, if you proceed without this understanding of the potential effects of trauma, you could have you could have an assumption or a presumption that the person is kind of evasive or not reliable because they can't remember all of the series of events in a linear manner that we often expect, right? In our investigations, we want to see detail. We want them to take us step by step. Okay, what happened? But that's not always possible in the context of trauma. And investigators out there have to be ready to move forward with the investigation based on what can be recalled by the individual. So we're doing decently for time. We are going to move over to some case law, which is always a favorite part of our presentation. And Florence is going to present a very recent case from Quebec.
Yes, thanks, Judith. So first, I wanted to discuss with you a very recent case from this summer that was rendered by Quebec's Human Rights Tribunal. So in the case of EB, well, first, before I start specifically with the case, gender identity and gender expression are fairly new concepts, especially within Quebec's legislation. So as Judith mentioned earlier, it was added to the Charter of Human Rights and Freedoms only in 2016. And since then, there's been not that many decisions on the subject. Actually, there's been one official decision where there were some comments, discriminatory comments that were made regarding gender expression, gender identity. But this decision is the first one in Quebec confirming that gender identity discrimination in the context of a hiring process is impermissible in Quebec. So we thought that it would be very relevant to discuss this with you today. So essentially, EB is a transgender woman and applied for a job as a waitress in a bar in Quebec. She did her training session successfully, was good. There were no performance issue, but she was then informed that she could not be hired due to her gender identity. So in the process, she was asked questions by the manager regarding her voice and her appearance, and then told the manager that she was in fact a transgender woman. In order to justify the non-hire of EB, the employer expressed concerns about the reaction of the clientele of the bar and also on EB's safety. And that those were the motives of the termination, but it was clear that it was due to EB's gender identity. Next slide. So the Human Rights Tribunal determined that the refusal to hire EB was, of course, discriminatory based on her gender identity, which violates the Quebec Charter of Human Rights and Freedoms. And the tribunal rejected all of the employers' and the managers' arguments and justifications to the termination. And the judge's opinion in the decision is very interesting and very precise. Essentially, regarding the security issue, the judge stated that it was not enough to simply claim a risk of danger of violence for refusing to hire someone. The risk must be real, serious and excessive, and no evidence to that end was presented in this case. The judge also mentions that the fear of economic business impact on the employer, such as a reduction of business volume due to customer disdain or contempt for a trans employee, can never be a reason for disregarding human rights. And the judge concluded by saying that you cannot justify a discriminatory treatment simply based on preferences and prejudices of client base. So essentially, the tribunal awarded EB with amounts for unpaid training, $10,000 in moral damages, and also a total of $4,000 in punitive damages against the employer, but also the manager personally, given his action and treatment of this file. So this decision really emphasizes the responsibility of employers to ensure a safe work environment for transgender employees, and also to not tolerate discrimination based on gender identity or gender expression. The judge even went a bit further and said that, in his opinion, it's mandatory and important to denounce such behavior, and that such behavior cannot be allowed or continue in Quebec. So we are likely to see more and more decisions going that route in Quebec regarding gender identity and gender expression.
Great. So we're going to move away from Quebec and go west to British Columbia in the January 2024 case of the BC Human Rights Tribunal. In this case, Mr. Glebov was terminated after posting YouTube videos that were preaching transphobic views contrary to the college policies. Mr. Glebov claimed religious discrimination and filed a complaint against the Fraser International College. So if we move on to the next slide, The college, in this case, applied to have the complaint dismissed on the basis that there was really no reasonable prospect that Mr. Glebov's complaint would succeed. In that context, the tribunal had to determine two different questions. First, it was whether the fact of publicly sharing his views about abortion, sexual assault, gender identity, and various non-Christian religions formed part of Mr. Glebov's sincerely held religious beliefs or practice. And secondly, whether his ability to practice that religion or his religion would be compromised if he were unable to do so. And by unable to do so, I mean if he were unable to publicly share those types of videos. Ultimately, the tribunal rejected the complaint at the preliminary stage. By way of background, just so you know who Mr. Glebov was, he was an academic instructor in the math department of the college. His employment agreement included various rules and regulations of the college. It included terms about harassment, termination, conflicts of interest, and also a code of conduct. And then when the college received an anonymous email informing them about Mr. Glebov's YouTube videos, they informed him that the videos were against college policies, and they suspended him with pay for the remainder of the semester. Then the college put in place an investigation, and really they were trying to assess the impact of the videos on the student population. And ultimately what they did is they terminated the contract that he had for the following semester. So in assessing the matter, the tribunal explained that really a dismissal application is not the same as a hearing. All that the complainant had to do in order for the matter to proceed to a hearing was to demonstrate that the complaint was not in the realm of conjecture. The college, for their part, they conceded that Mr. Glebov had experienced adverse impact, right? He had lost his employment, but they argued that Mr. Glebov would not be able to establish a nexus really between his conduct on YouTube, and to say that that really arose out of a sincerely held practice or belief from his religion. So the tribunal agreed with the college on that front. And I'm going to quote from the tribunal. It says, "The sincerity of a complainant's religious belief is a question of fact based on their credibility and factors such as whether their alleged belief is consistent with their religious practices at the material times." So here in this case, Mr. Glebov, of course, had testified, and what he said was that his views were based both on the King James Bible and Russell Ree Manning's book, 32nd Religion. He stated that he read chapters from this book during his sermons on various religious beliefs, and he contrasted them with the religious beliefs revealed in the King James Bible. According to him, the statements that he communicated were true, and he believed them to be true. But what he didn't do was to provide any basis for saying that the fact of the public videos or the fact of publicly disseminating his views was really related to the tenets of his faith, or that his ability to practice his religion would be compromised if he wasn't able to do those public statements on YouTube. So the tribunal contrasted the case in front of it with another case where in that other case, the complainant had shown a link between distributing flyers containing views about transgender people and the complainant's religious beliefs. But because there was insufficient evidence in this case, the complaint was dismissed. So that is Mr. Glebov and the college. I'm looking at the time, and I want to move federally now. So we'll have had BC, Quebec, and a federal case. This federal case is of Bilac is a recent case from 2023. Bilac is a transgender man who uses he, him pronouns, and he was assigned another name at birth, which he was not able to legally change. And throughout his employment in a small town for NC Tractor Services, he was repeatedly dead named misgendered, and asked invasive questions about being transgender. Remember, we talked about these types of invasive questions. So ultimately, Bilac feared for his dignity, his safety, his privacy. He was concerned that that all of these factors were not being taken seriously by the employer, and he resigned from his employment. The tribunal found that the respondents in this case had acknowledged, right, that they had misgendered and dead named the complainant, but they continued to do so directly with him, with other employees and friends from the community who visited the workplace. The complainant in this case, he was particularly vulnerable because he feared being outed as a transgender man in a small community where he had moved to accept the job. The complainant's loss of employment in this case was clearly a byproduct of feeling he had no choice but to leave a workplace that failed to respond to his request to use his name and correct pronouns. So I want, here it was adverse treatment with respect to the complainant's employment, and what the tribunal awarded here was $18,000 as compensation for injury to dignity, feelings, and self-respect, accepting in this case that the respondent's conduct was really consistent and reckless, and that favored a higher award. I want to give you a quote from this case that quotes from the Goodberry case that you may have heard of. It's Nelson versus Goodberry from the British Columbia Human Rights Tribunal. And what it says is, transgender employees are entitled to recognition of and respect for their gender identity and expression. This begins with using their names and pronouns correctly. This is not an accommodation. It is a basic obligation that every person holds towards people in their employment. So again, not an accommodation to be using the correct pronouns and names. In Goodberry, the damages in that case were $30,000 in addition to orders to have a policy and some training requirements. Both Bilac here, this federal case from, and the Goodberry case, deal with the employer's response to the situation, and both make it very clear that an employer has a duty to promptly engage and investigate harassment and discrimination complaints. I'm going to look at time. So 2 more interesting pieces from the Bilac case, just so you have a better sense of what the facts were. During the hearing of the Bilac case, the respondents continued to dead name Bilac and use the wrong pronouns, even after having been corrected both by the tribunal member and Bilac's counsel. And there was an interesting piece that was also made about the question of one of the individual respondents in that case. And it was about which washroom that Bilac used. And the tribunal found that that added to the discriminatory harassment he experienced, especially in the context where, in fact, in that workplace, there was only one washroom. And because Bilac had stated that he had made a good faith effort to try to educate his colleagues, his employers, about his transgender issues, but eventually came to experience all of their questions as unwelcome, and he really felt that the respondents were ganging up on him. So if we move on to the next slide to see where it takes us from here, EDI considerations and conversations are important, as you will hopefully have learned during this session today. They're important for continued success, whether it's from a retention perspective or attracting talent, or even for your social profile as an organization. And the responsibility is really on everybody to listen and take action. It's not about just affecting those who are affected, and they're not the only ones who are responsible to move forward. And I'm going to take a few seconds because I saw some questions coming in, so I'll look at more of them. But one of the main questions that we received over and over again in advance of the session was dealing with the theme of how to get people engaged and dealing with some pushback and attempting to drive change in the EDI space. So one of the questions was specifically, how do you get leadership involved or to buy into the diversity and inclusion efforts of an organization? Because we all know, without active support from the top, it's going to be really hard to build a truly diverse and inclusive culture. So we thought we'd give you a few ideas. And the first one really is go back to the data. Most executives care about data. So consider presenting some of the statistics that we shared at the beginning of the presentation. Hopefully showing them, that there is value to EDI, both from a social and economic perspective, but get internal data as well. Go back into your organization and try to look, for example, where there are some diversity concerns. And Florence mentioned these, right? Like, is it in your recruitment process? Is it in promotions? Is it in employee turnover? You may find out in an exit interview that a person left because of perceived lack of support for EDI initiatives. So look for real life examples within your organization that you can share with management, and then offer training or to your leadership team, because a lot of leaders may not have personally experienced exclusion, and they may feel that they don't have all the necessary skill sets to be able to be those champions for EDI initiatives. They may be afraid to do the wrong thing or to approach something the wrong way. So try to identify, give them some training, find some champions, and don't try to do everything at once. Try to take it one piece at a time, something small where you can have some success. And hopefully by showing them that it was a manageable task and seeing the positive results from that, then you'll get other leaders to get engaged. So I don't know, Florence, if you wanted to add anything to that.
No, very complete answer.
Okay, and I'm looking at the other questions. One of them was really this idea of duty to investigate, asking whether it is linked to a complaint. And as I mentioned, certainly in Ontario, it is not. So you want to be careful about your duties where they arise in Ontario, whether you have a complaint or not. If you're aware of an incident of harassment, then you need to investigate. But generally, right, as we're saying, in terms of driving change and championing EDI initiatives, you want to consider that as well if you're having some concerns being brought to your attention. So I see now that we have the last slide in front of us and we are at time. So I'd like to thank you as the audience and thank Florence for being here today. For those in Ontario, this session qualifies for 1 hour of your EDI professionalism credits, and you're going to receive a CPD certificate within next week. For our Quebec viewers, a certificate of participation is also going to be sent out within the next week. And for our BC viewers, the Law Society of BC title has been added to the chat. So our next webinar in our 4-part series is October 10, and it is on the topic of, is this too personal? A look at the benefits and pitfalls of EDI data collection. So if you want to register for this event, you can go to Fasken Institute at fasken.com, and you'll see all of our upcoming events. So thanks again for joining us, and have a great rest of your day.